care.
I'm glad you both brought up Thomas, because one of the things he wrote in his concurrent opinion was this right of privacy and how this can affect gay marriage as well, because isn't gay marriage also held on the same rights that abortion was held on?
That's right. And I had mentioned before, there were several cases predating Roe, which Roe was predicated on. Those were sort of the substantive due process cases, the right to privacy cases, cases that had found within the 14th Amendment and other places as well, the right to privacy. And then post-Roe, there were several cases as well that, and Obergefell is one of them, Lawrence is another, which both deal with LGBTQ rights. And those are explicitly founded on the same principle of privacy. And so for Thomas to suggest, if in fact that's what he does, that that the majority opinion in Dobbs will or should have no effect on anything but abortion is garbage. That's just not how the law works, right? He's in my view, what he's doing is sort of shopping for cases, right? And very, not for nothing, the one case that Justice Thomas omits from that list of cases that he cites as not being affected is Loving v. Virginia, which is the case that allows interracial marriage as a privacy issue. And, you mentioned before the equal protection argument. There have, some of these cases have been, there were arguments made and potential for the court to have decided these cases on different grounds, right? There's not just one way to decide a case. It could be because of the statute says this or the statute says that. And the court reasons, these things separate or together lead us to this conclusion. And so there were arguments made in most of these cases, in some of these cases, I should say, on equal protection grounds, right? You have to uphold or strike down this statute because the equal protection of laws is required, and this statute doesn't meet it. Well, but ultimately, those cases were due process cases. So even if equal protection was argued, the actual holding was due process and privacy. And so for the court to now say, or suggest, Thomas rather, to suggest that those cases are safe from attack, nobody should believe that for a minute. And everybody, again, going back to your original question about whether this issue is on the ballot, it is on the ballot because as states now have the right to decide how these issues, whether it's fetal personhood or whether it's contraception or whether it's, marriage, this issue is here now, and it was foisted upon us by this.
And now there's this.
I just have a point of information. So post Roe, there was, I'm just forgetting the name of the case of the two men in Georgia that were having sex, and they were criminally charged with sodomy, and the court ruled that they didn't have the right to privacy. So even after Roe, the right to privacy did not necessarily protect gay people. So even though it wasn't enforced in most states did have anti-sodomy statutes on the books. And in Georgia, I can't remember the name of the case, but it was terrible. They ruled that these two guys were criminally liable for having sex with each other in the privacy of one of their homes. So,
and look, privacy. The question of privacy has not always inured to the benefit of LGBTQ or women in particular, right? Privacy laws were the guise of privacy was what kept until the 70s in some states marital rape laws off the books, right? It wasn't a crime to rape your wife in a lot of jurisdictions until very late, and the reason, because that's a private issue, right? We don't get involved in people's home lives, right? You can beat your children. That's a privacy issue, right?
Thank you for watching the clip. Please don't forget to subscribe to my YouTube channel, and also stay tuned for more In the Cann with Carmella Cann.